Thank you folks for coming to the seminar tonight. We're going to spend about an hour together talking about wills and trusts and power of attorneys and other estate planning strategies that will be important for you to understand. I doubt that this is the first time any of you have thought about this. People think about this subject, but oftentimes they procrastinate and put it off for years sometimes even decades. First thing I want to do is I want to spend a little bit of time talking about probate. What is it? How does it work? Why is it that all of the experts tell you to avoid probate? Most of you know that probate is the process whereby the state examines a deceased will and determines where the assets are going to go. This is in money matters. It's in virtually every major Sunday newspaper in the country. And they say that probate decides where to distribute your assets. There's three things you can do. There's a do-nothing plan where you just live your life and don't do a will or anything, and then after you pass on, the state of Tennessee or whatever state you live in will provide a will for you. The second plan is to do something. That's to do a will, to have an attorney create a will for you. To create a properly executed will with all the power of attorneys, the living wills, the wills, etc., for a married couple usually ranges between $800 and $1,200. The problem with that is that will still has to probate. By definition, the will is a letter to the probate court. And then the third thing you can do is you can do a complete estate plan. You can eliminate the probate process. You can eliminate having attorneys and courts getting involved with how you want your assets distributed. And that's by preparing what's called a revocable living trust. The first thing we're going to spend time on, like I said, is probate. Probate has three main problems. First, it is time consuming. An estate that goes into probate ranges anywhere from about 9 months to 2 or 3 years. It varies by state. It varies by the type of an estate you have. It varies by how many times people are going to fight over things. As you know, there's a lot of greed that takes place when a person passes on. So with the probate process, it does take time. The second problem is it costs money. It's not free. There are accounting fees and appraisal fees and court fees. And then the biggest fee of all is the attorney fees. Attorneys love to do wills. The Wall Street Journal says lawyers would rather write a will for several $100s and then make a bundle when it goes through probate. Because again, the money is made in the probate process. And by the way, it's fair that they're paid for this. This is a complicated legal matter, and attorneys should be compensated for this. The actual cost to go through the probate process, it varies in every county in the country. Somewhere between 5 and 15% of the value of your estate is what it will cost to go through the probate process. That means that if you have a home that's worth a couple of $100,000 and you've got a car, and you've got other financial assets, it's going to cost 5% of that to go through the probate process, but it's also going to take a year or two. And what that means is that if you die today, your kids won't see your assets for 15 or 18 months while it's going through this process. That's the problem. The third problem, though, is probate is a public arena. Everybody's privy to what you do with your estate plan. You've probably read the newspapers before where you've seen the obituary section, haven't you? Right next to the obituary section is what? Public notices. And in the public notice section, all the personal information is listed. When wills are going to be read. All things that really are private that become public. And that's what the experts tell you to avoid. Some people have the misconception that, well, my executor, I've appointed my son as my executor. When I die, he's just going to settle the estate. Now, you would think that would be the case, but that's not how it is. The son is going to hire an attorney who's going to take the estate through probate. And a year and a half or 2 years later, it's going to come out and will be distributed, hopefully, the way you've asked it to be done through the will. I can't think of anything worse than my wife and I living our life, accumulating our estate, and then after we pass on, have a stranger decide how our assets are distributed. But that's what happens when your estate gets into the probate process, because a judge is going to do this. They may very well do what your will says, but they don't have to. They can do whatever they'd like to do. And even if they do what your will says, there are still time delays and costs involved. The reason so many people tell you to do a revocable living trust is with a trust you eliminate the probate process. There is no probate. And my wife and I have a trust. When Judy and I pass on, our kids will not spend a minute in the probate process. They'll simply transfer our assets into their name as soon as they have our death certificate. So it'll take a week or two, but it's not going to take a year or two. They're also going to do this without spending any money. There are no fees for this. There are no accounting fees and appraisal fees, etc. They don't need an attorney to do this. So they do it quickly, they do it without spending any money, and they do it privately. Is it any wonder why so many experts tell you to do this? Forbes Magazine said trust to trust. They wrote an article that says, have you set up a trust? If you haven't, get cracking. No middle-class person should be without one. This doesn't say some of us. This also doesn't say all you rich people. The rich people have trusts. People like you and I started taking advantage of this about 30 years ago because we determined that our $50 was worth every bit as much to our family as Mr. Kennedy's $1 million is to his family. It's all relevant, isn't it? My wife and I are not millionaires, but we know one thing. We're going to control our assets while we're alive, and then after we pass on, we know for certain that our assets will go to who we want them to go to without delays and people getting involved and all kinds of issues to deal with. Because we've taken the step to put a foundation in place for our estate plan, and that's the Revocable Living Trust. USA Today says, planning now can ward off financial catastrophe. AARP says, if you look forward to going to the dentist or paying taxes, you'll love probate. Isn't that interesting? See, when you think about it, we're told that we should be good stewards of our funds, aren't we? How do you do that? Well, you do it by doing things like this. I see no reason why a court or an attorney or a judge or anybody else should get these assets when I can make certain that they can go to my family and my church and other charities that we're involved with. This is called a revocable living trust. It's revocable because you can change it whenever you'd like to, and you will. Life changes, family members change, assets change, everything changes. The nice thing is it's very flexible, and you have 100% control of everything. It's a living trust. It lives with you for the rest of your life. You're not going to start the process here this evening and 5 years later need another one. You don't need another one. You have one. You won't move to another state and need another trust. This trust goes with you. You are the trustor of your trust. That means you own it. It is yours. You're going to give your trust a name. You can name it anything you'd like to. Usually it's your name, but you could put any name on it. And then you will appoint trustees. The trustees are the most important people within the estate plan. The trustees control the assets. The trustees buy and sell things, open and close accounts. The trustees make every decision with regard to your estate plan. You will appoint yourselves as the trustees of your trust. My wife and I are the trustees of our trust. Our trust actually reads Gene and Judy Adams, trustees of the Adams Family Trust. And now we just get on with things. We don't need to contact attorneys to get permission to do things. We can buy and sell things. If we have questions, we simply call. There's no fees for that as part of our service and get advice. But the nice thing is we control the assets. We make every decision. When I die, my wife is still the trustee. Judy does not have to change asset titles or business titles or real estate titles. She doesn't have to go through probate on any assets that are held separately. She continues on. This gives me peace of mind. My wife will be devastated when I go. If she goes first, I'll be devastated. But the nice thing is we can do things on our own terms. And I've talked to a lot of widows and widowers. The emotional impact of losing a spouse is devastating to people. And the nice thing is you can do it in your terms instead of getting courts and attorneys involved with you. Now, after Judy dies, whether Judy and I die in an accident together or whether Judy dies 30 years after I die, the trust is going to change. The trust is now going to become irrevocable. Now remember, it was revocable while we were living, meaning we could change it and do anything we'd like. After the one spouse passes on, it is still revocable. After the second spouse passes on, it becomes irrevocable. And the reason it's irrevocable is we don't want our kids changing things. We want them to follow legally what we've instructed them to do. And what we've done is we've appointed what's called successor trustees. They succeed us. They take over for us. It's kind of like the presidency. When John Kennedy was killed in 1963, we didn't run out and hold another election the following Tuesday, did we? Of course not. Can you imagine the chaos that would have taken place in this country? Thank God that our founding fathers had the wisdom to have a succession process in place. Well, the chaos that takes place in the probate process is eliminated because you have successor trustees. Now, you can appoint anybody you'd like. You can appoint as many people as you would like. We've had people appoint some of their kids, none of their kids, all of their kids. My wife and I appointed our 2 children together. Our 2 children are actually called co-successor trustees. That means they do everything together. And this is what our 2 kids will do after Judy and I both have passed on. They're going to take one section of the trust. It's the declaration of the trust. It's a section that says what their powers are, and it also identifies them. So it says who the trustees are, who the successor trustees are, etc. They're then going to go down to the county clerk with identification and our death certificates, and they're going to transfer our real estate into their name. They'll then go to the banks, the financial institutions. They'll do the very same thing. They'll do it quickly, they'll do it without spending a nickel, and they'll do it privately. Isn't that a lot better than the alternative? Because the alternative is this. We've got $50,000 at Bank of America, we die, our kids go to Bank of America as the executors of our will, and they tell Mr. America, our parents have died, would you please give us their money? What do you think he tells them? You can't have it. Mr. America says, well, you need to process that, and it'll go through the probate area, and then I'll be happy to give you the funds. So they leave. By the way, they can't even get into the safety deposit box without a court order. And once that safety deposit box is open, it's open for everybody's view. It becomes public knowledge rather than private. Well, that won't happen with us. When Judy and I die, our kids will transfer our financial assets, our real estate assets. They will privately go into the safety deposit box room and empty it out, and they'll get on with life. How come they can do that? Because we told them to. We made certain that our assets were in the name of the trust, meaning that we are the trustees of these assets while we're alive, and after we die, our successor trustees automatically become trustees of these assets. This gives you the rare ability to control your assets while you're alive, do what you want to do, when you want to do it, and after you pass on, pass it on to your kids or other family members or churches or whoever you'd like to pass it to without any court interference. We have a section in our trust that's called the Guide for the Successor Trustee. We actually tell the successor trustees what to do and when to do it, how to settle debt, how to handle the IRS, what to do about Social Security. We walk them through the whole process in plain English to make it easy for them. When my wife and I pass on, our kids will be devastated. This is an easy way to help them in that area. But the other thing that's nice is if they have questions, they simply call the toll-free number and our legal office will help them. So you get the ability to do these things and then also have help afterwards. You can change this section anytime you'd like to. The successor trustee section rarely gets changed. But if you want to change the successor trustee, change it. In order for us to change our successor trustee section of our trust, we'd have to have a falling out with our kids. If we do, we're going to change it. So that's important for you to understand. But it's very important for you to know that until both you and your spouse, or if you're a single person, you pass on, the successor trustees have nothing to do with your estate plan. It's strictly 100% yours, and it's handled privately. You need a will. This is a special kind of will. This will is called a pour-over will. P-O-U-R, pour-over will. It has 3 main purposes. First, it supersedes any will you've ever had. So all of your old wills are canceled because you have a new will that cancels the old will. Guardianship issues are dealt with in the will section of the trust. More and more people are doing trusts with minor children. This is a crucial area for people. You certainly don't want court-appointed guardians. You also could have words of wisdom for people, or animals you want to leave to somebody, and money for them to take care of these animals. That again is made known in the will section of the trust. And then after you die, the will is poured into the trust. It becomes part of the trust. There's nothing in that will that's probatable because we've made sure your assets are transferred into the trust name. If you're married, there's a separate will for each of you. They're crucial documents. They are included in the estate plan. Then there's a section called distribution of assets. You know this as beneficiaries. Who are you giving this stuff to? Well, it's up to you. That's what's nice about it. Nice thing about it is it's very flexible as well. I always tell our clients, do it as good as you can do it. But remember, you can change it anytime you'd like to, and you likely will, because your life will change sometime down the road. My wife and I did this all in percentages. We left a percentage to our church. We left a percentage to charities that we're involved with. We left a percentage to our grandchildren, and the rest to our 2 kids. We did not want our grandchildren to get their inheritance all at one time. What is the very first thing a 16-year-old will buy with an inheritance? Of course. What color is the car? Red. Yep, it's a red car. But we didn't want that to happen. So we say they don't get a nickel till they're 18. The rest they get in small increments up to age 30. Most of it comes after they're 25. We know when they're 30, they'll be better prepared to distribute these assets and do things with them. I had a couple at a seminar one day tell me that their parents had left $80,000 to their daughter. So the grandparents left $80,000 to the granddaughter. And they said that she went in 6 months, she blew every penny. She bought the car, she partied, she took her friends on vacations, and there was nothing left. Isn't that sad? They could have given her $25,000 and put the rest in some kind of an account that might have been worth $150,000 when she became 30. But instead, they floundered the money because they weren't proactive in getting these types of things done, you see. You could have a child that receives SSI benefits. If you leave that child money, the government's going to take over that money because of the old SSI benefits and take back the benefit. With the trust, our attorneys will prepare what's called a special needs section of the trust, which will allow you to distribute assets to that child without it going directly into their name. That way it's protected. You could have somebody that in your family that you want to leave assets to that has a drug or an alcohol problem. And if you leave the money, you know where it's going to go. In that case, our attorneys will prepare the document so that you can distribute it differently. There's all kinds of different things you can do that's flexible with your trust. You can't do these types of things with wills. This gives you the ability to be as flexible as you like, as often as you would like, and then down the road you can change it if you'd like to, because you have 100% control of everything. Again, you have the ability to contact the legal office anytime and ask advice. They'll help you with basic changes to your trust and help you get through the process if you'd like to. But it's up to you, because we don't have control of any of your assets. It's all 100% taken care of by you. Now, you also may be in a position where you have what's called gifts prior to distribution. Antiques, collectibles, jewelry, baseball cards, gun collection, stamp collection, coin collection, whatever it may be. If that's the case, let the attorneys know that when they're preparing your document so they can make note of that and prepare it in the language that you'd like it to be prepared in. Then there's a section, it's called funding your trust. This will answer your question, sir. If you have a trust, but your assets are not in the name of the trust, those assets actually go to probate anyway, the trust just becomes a will because you haven't taken the step to transfer these assets into the name of the trust. We have determined that if we don't transfer your assets for you at the beginning, they probably won't get transferred properly. So we do the asset transfers for you. The way it's handled, those of you that start the process with us, you will get a welcome letter, and there will be an envelope in this welcome letter that will ask you to put a copy of your property tax bill and your real estate deed in. That will be sent to our office. Our legal office is going to prepare a new deed. They're going to deliver it to you. It's going to be notarized, and then it's going to be filed in the county office. You will get a new deed. Your tax bill will come to your same address it always comes to, but instead of just saying your name on it, it will now say your name trustee, meaning that it's in the trust. You see what's happened here? You still control the asset because you're the trustee, but instead of being it in your name, it's now in the name of the trust, which avoids the probate process and will allow your successor trustee to take it over. If you have a house in another state or financial assets in other states, there would be a probate in each of those states. One trust eliminates probate all over the country. You may have a vacation home in Florida. You may have a rental house down the street. If you do, it's important that they are retitled into the trust name as well. We do all of those for you in order to get the process handled in the manner that will best benefit you. By the way, if you want to sell your house, all you do is put a for sale sign in your yard. Remember, you have control of everything. Nobody else has any control. The other nice thing is when you buy a new house, you simply tell the closing officer that you would like them to put that house in the name of the trust. That way what's happening is you're selling a house that comes out of your trust. When you buy a new house, it automatically goes in your trust. There's no special things you have to do. You just have to remember to tell the closing officer, please title that home in the name of the trust. Doesn't change your taxes. Interest rates don't change. Nothing changes whatsoever. The difference is when you pass on, the successor trustees now have access to those assets. You have other assets though. Bank accounts, investment accounts. CDs, money markets, what happens with those? They have to be retitled into the trust name. The way that's handled, remember I told you the third step was we make an appointment and come to your home and deliver the trust to you? Remember that? Well, when we come there, the licensed notary is going to do all of the notarizing for you to get all the documents taken care of. They're going to explain the document to you so that you understand it thoroughly, and they're going to transfer your assets into the trust. So your bank accounts now will stay in the same bank, the same account number, but instead of the monthly statement coming to your address saying your name on it, they will now come to your address and say your name, trustee, meaning that they're in the trust. You have to treat this document like it's a safe. You have important documents that you want to protect. You don't take those documents and put them on top of the safe, do you? What do you do with them? You put them in the safe. So we're going to put them in the safe for you from the get-go, and then after that, it's your responsibility to keep it up. If you have questions, you can call. That's fine. The nice thing is, if you decide you don't like Bank of America anymore, that's fine. You go take your money out, and when you take your money out of Bank of America, it's out of the trust. And maybe you go to Washington Mutual and say, I'd like you to open an account. You have a pretty good CD rate. Would you please open my account, what? In the name of my trust. See how easy this is? The difference between all of this is that all of these assets now are in the trust. My wife and I control all these assets. When we die, our kids now, we're handing it off to our kids, and they can now control all the assets that are in the trust. It's a remarkable way of handling these estates and eliminating all the guesswork that takes place by allowing a stranger to make these decisions for you. Every state is a little different. In the state that we're in, you can have $25,000 out of the trust that's not probatable. So if you have a vehicle that's worth $30,000 or $40,000, I'd consider titling in the trust name. If we have two vehicles, one is